Welcome back to my space. I still remain Aisha Ochuwa, and today I am here to talk to you about labor law. Now, I want you to pay a very good attention to this particular discussion because it is very important in your business. It involves both you, the owner of the business, and all your employees. Labor law is simply a legal framework that governs the working relationship between the employer and the employee. It governs all your activities for hiring practices, termination of employment, dispute resolution, benefits, minimum wage, working conditions, health, and all the safety regulations. The Nigerian Labour Law Act of 2004 is the governing legislation, and it covers the employment contracts, working hours, minimum wage, holidays and leave, trade union, health and safety, and the termination of employment. It is important to note that the Labour Law Act uses the word workers to define employees, and it defined workers as not including persons who have administrative, technical, executive, or professional functions. Now, the Labour Law Act makes clear certain points that are mandatory in the employee-employer relationship, and these points must be followed to the letter. The first one is no forced labor. Every citizen of Nigeria has the right to be free from forced labor. For this reason, you cannot force anyone to work for you under any circumstance. That is what the Labour Law Act provides. You cannot force anyone to work for you. It has to be out of the person's free will. You can't force labor. Now, the only exception to this is the power the Act gives to the government to make people work during emergency situations. Now, in this kind of situation, it will not be regarded as forced labor. So as far as the Act is concerned, there must be no forced labor. That is the very first point. The very second point is the contract of employment. Now, the Labour Law Act provides that every employer must provide an employee a contract of employment within the first 3 months of the employment. Now, this contract of employment must expressly state all the terms of the contract, the benefits involved, remuneration, every other key point that has been discussed orally. Everything that was discussed orally during the employment process must be put into writing within the first 3 months of the employment. So if you employ someone within the first 3 months of employment, you must provide the person with a contract of employment. And if there is any change in the terms of that employment, it must be put into writing and same communicated to the person in writing within 1 month of that change. That is what the law provides. Now, the third point that you must take note, because this one applies to a whole lot of people that love to be smart. The third point is remuneration, payment, money, payment of your staff. Now, the law provides that every employee must be paid with actual cash, not kindness. That is what the law provides. The law states that any contract where the whole or part of the worker's wages is made payable in any other manner apart from legal tender shall be illegal, null, and void. This cancels your attempt to pay that person with kindness in the future. This cancels your attempt to pay that employee with kindness, with favors, with promises. Every employee must be paid. The law also frowns at any payment scheme that exceeds a month interval. Simple and short, every employee must be paid monthly. Every month, you must pay your staff. Any payment that requires, any work scheme that requires payment, that is not a contract or that is not an express contract or service. We are talking about an employment. Every employment should attract a monthly payment. You will pay every month. You will pay your staff. Employer, you will pay your staff every month. every month. That is what the law provides. Another interesting thing the Act provides under remuneration is that you cannot dictate to your employees how they spend their money. For example, you're a shoe vendor, a bag vendor. You cannot force your employees to buy your bags at the end of the month. Because you have paid them salary, you feel the money is hot in their hand. You now tell them, everybody, nobody's leaving this store today without buying at least one shoe. You can't do that. The law frowns at that. You cannot dictate to your employees how to spend their money. If they want to buy your products, that will be out of their own free will. Now, it may seem like the law is very partial to, the law is against employers, but that's not true. Here's one interesting one. The law provides that an employee is not entitled to an upfront payment of over a month. So an employer should not pay an employee, under the law, an employer should not pay an employee an upfront payment that exceeds 1 month. So if you decide to do that, it's out of your free will, out of the kindness of your heart. Under the law, you cannot pay an employee an upfront payment that exceeds 1 month. So for those employees that want to get 6 months advance payments because they want to go and do their grandmother's burial, that's none of your business, ma. It has nothing to do with you, sir. According to the law, if you are to follow the law stricto sensu, 1 month, if you feel they deserve it, 1 month. Anything that exceeds 1 month, you have the right to say no. The next point that the Act clearly expresses is rest hours, sick leave, and holidays. Now, the Act provides that if a worker is to be at work for 6 hours straight, that worker is entitled to at least 1 hour of rest within those 6 hours of work. This is in recognition of the fact that the body is not firewood and everybody needs rest. So if your workers are going to work for 6 straight hours, under the law, it is their right to be entitled to 1 hour of rest to refreshing their mind, to serve you better. The law also provides that for every 7 days of work, the workers are entitled to at least 1 day of rest, which should not be less than 24 consecutive hours. Meaning, there are 7 days in a week. If your workers are to work for the whole week, they must have at least 1 day, not less than 24 consecutive hours. So, you are not to give them 10 hours of rest or 12 hours of rest and force them to come back to work. For every 7 days, they are entitled to 24 hours, 1 day of complete rest, nothing short of that. Now, for workers who are sick, they are entitled to 12 days of sick leave. For sicknesses that are certified by, verified medical practitioners, then the worker who is sick is entitled to 12 days of sick leave. Now, after 12 months, the law provides that workers are entitled to at least 6 working days with pay. At least 6 working days of holiday with full pay. They should be paid for those working days. So the law provides that for every 12 months of work, the workers are entitled to 6 working days of rest, of holiday with full pay. Now, this brings me to maternity leave. I know a lot of employers don't like to hear this because they want you to be at work and they don't want to pay you for getting pregnant. But the law provides that every nursing mother is entitled to 12 weeks of maternity leave with full pay. Yes, you have to pay her. If she's a woman, you have to pay her. So the law provides that every nursing mother is entitled to get 12 weeks of maternity leave with pay. It's a provision of the law. I didn't write the law. The authorities did. So you have to do it. It's their right. I'm sorry if this hurts you, but it's just the truth. You see, I love the Labor Law Act because it checkmates the activities of employers, all the excesses of bossiness. Now, this one, a lot of people will be offended, and I'm sure people who don't have a problem with a conducive work environment won't have a problem with this one. Now, this brings me to salary deduction. The law prohibits employers from unjustly deducting from salaries of employees. Any deduction is illegal except for an injury or a loss caused to the employer by the employee. Now, if the employee makes you suffer an unjust loss, an unreasonable loss, an avoidable loss, then you can deduct from the person's salary. This is because the law recognizes that you shouldn't be made to pay for someone else's negligence or wickedness. So if that is the case, if there is a loss suffered or an injury suffered, then the employee should pay you. There should be some form of deduction. But for things like, you came late to my office and deducting 10,000 from the salary, no, that's illegal. You can't do that. You don't have the right to do that under the law. You can issue a query, you can suspend, but you don't get to deduct from that employee's salary. Also, for a case of an overpayment, for example, you overpay your employee or you send money wrongly to your employee's account, the law provides that you have to withdraw that overpayment. You have to remedy that wrong done within the first 3 months of the overpayment. If you did not know that you overpaid your employee and maybe realized after 6 months, you have dashed that person money in the eyes of the law. After the first 3 months of that overpayment, you do not have the right to withdraw that money from the employee's account or request for the money from the employee. Once the 3 months lapses, the money is gone. It's good as dashing a person the money. And the law considers it illegal to request or forcefully withdraw that money or deduct it from future payments. It will be illegal. This employee can take actions against you. Yes, that's the provision of the law, sis and sir. Now, this brings me to the very next one, which is trade unions and other labor associations. It is illegal under the law for you to prevent your workers from joining, trade unions and associations of their interest. And it is illegal for it to be a part of an employment contract. Any employment contract that includes or prevents an employee from joining a certain trade union, especially those that have to do with the person's self-development and career, any such contract will be deemed illegal. It is illegal for you to prevent employees from joining trade unions and associations. As minor as it may sound, it is heavy in the eyes of the law. So take notes. The very next point is transfer of employment. Now, please take note of this. A lot of people are guilty of this, but they don't even know. And a lot of employees have the right to decline, but they are not aware either. The law provides that there cannot be a transfer of employment from one employer to another. For any such transfer to be valid in the eyes of the law, the consent of the employee must first be sought. This means that if company A is taken over by company B, that does not mean an automatic transfer of all the employees from company A to company B. Before any such transfer can be valid, there must be an obtained consent of the employees of company A. Meaning that transfer automatically or indirectly terminates the contract of employment, because that contract of employment was with company A. So if there is going to be a transfer of that contract of employment to company B, the employees in question must be in the know, number one. They must agree to it, number two. So it's not okay that, company A, there's been an acquisition, company B has taken over company A, therefore all the staff that company A had initially will automatically work for company B. No, that's not how it works in the eyes of the law. If the employees do not agree to it, that transfer will be deemed void and invalid. For it to be valid and for it to be approved and acceptable in the eyes of the law, the consent of the employees must be sought, they must be in the know, they must agree to it. That is the provision of the law for transfer of employment. Now let's get to the very last point I'll be mentioning in this video. This is termination of employment. There is a general misconception that the applicable notice period for every employment is a time frame of 2 weeks. This is not true. Different stages of employment, by stages I mean time frame, different stages of employment attract different notice periods. The first one we'll be addressing is for an employment of a time frame of 3 months and below. The law provides that either party may terminate the employment contract with a notice period of at least 1 day. So if you just employed a staff and you realized the staff probably twisted or told a few lies in the employment process and the person is not living up to the employment standards, you may terminate the employment contract with a notice period of 1 day if the employment contract has been for a period of 3 months or less. That's the first one. Secondly, when the employment has been for a period of 3 months but less than 2 years, either party may terminate the employment contract with a notice period of 1 week. That's what the law provides. Where the employment has been for a period of 3 months but less than 2 years, either party may terminate with a notice period of 1 week. So the general misconception of 2 weeks notice, employers try to put people on lock until they get a replacement and say you must stay for 2 weeks. If the employment has been for a period of 3 months or less than 2 years, the staff is entitled to give you a notice of 1 week. If the employment has been for a period of 3 months or less than 2 years, you are entitled to give that staff you're about to sack a notice period of 1 week, not the 2 weeks that everyone thinks. That's the second point. The very third point is where the employment contract has been for a period of 2 years or less than 5 years. So now we're talking about 2 years or less than 5 years. Then the applicable notice period to terminate by either party would be 2 weeks. So where the employee has worked for you for a period of 2 years, but not up to 5 years, less than 5 years. If you want to sack the person, if you want to terminate the contract, the applicable notice period you are to give the employee is a period of 2 weeks. Where the employee wants to resign from the job and the person has worked for a period of 2 years but not up to 5 years, the notice period you are entitled to is 2 weeks. This brings me to the fourth one. The law provides that when the employment contract has been for a period of 5 years or more, 5 years and above, the applicable notice period is 1 month. 1 month. Where the employee has worked for you for a period of 5 years, for over 5 years. If you have to terminate that contract of employment, you have to give the person a notice period of 1 month, not less than 1 month. Where the staff has worked in your organization and the staff wants to terminate the contract of employment, the notice period you are entitled to is a period of 1 month, not less than 1 month. And now the law also provides, most importantly, that every of these notice for each of the periods must be in writing. The notice must be in writing. The law provides that. It is mandatory. It has to be a notice in writing for it to be valid. It is important for both parties, both the employer and the employee, to digest all of the labor laws, all the provisions of the Labor Law Act. It is important in your employment contract. It is important in your employment relationship, whether you are an employer or an employee, you should understand the provisions of the labor law. That could help you. That could save you a lot of stress. That could save you a lot of losses. Read the provisions of the Labor Law Act. Digest them. Apply them where needed. Apply them in your relationship, in your employer-employee relationship. Before you employ a staff, before you put out your applications to employ new people to join your new company, know what the law provides, know what the labor law provides, so you don't employ people who will sue you. Ignorance is not an excuse before the law. Ignorance is not an excuse. The fact that you did not know will not exonerate you of whatever punishment that will be applicable to you by law. So understand them. This way, you avoid every problem that has to do with labor law, and you have a smooth sail in your journey. I hope you listen to this. I hope you apply these rules, and I hope your journey through employment becomes easy for you, because these are little things that we could easily avoid that could get us into a lot of trouble. So read through the Labor Law Act, digest every single point, every single law, apply them into your daily activities, and the sky will start